really important development in patent reform has been the introduction of the Patent Eligibility Restoration Act. Long title, we call it PERA. It addresses these really bad Supreme Court decisions from about a decade ago that have completely undermined the ability of innovators in the biotech and the high-tech areas of the U.S. innovation economy from receiving reliable and effective patents, essentially excluding innovations in that space. This is incredibly important for ensuring the continued growth of the U.S. innovation economy and for addressing competitive challenges faced globally from countries such as China.
First question is just, we attended a recent U.S. Inventor call with Judge Michelle. Judge Michelle was super generous for this time. It was a very long, super constructive call. And I don't know that U.S. Inventor is officially taken a position on this yet. They tease that they might be soon. But like I said, super constructive conversation, but there were some lingering concerns. So, the judge said that, I think his quote was, "Process is the tricky one." This version got rid of the term non-technological, which was definitely one of the bigger hangups that we talked about, with the prior version. Judge tried to clarify, and he said that, if a computer or machine is involved, that it's essentially eligible, but if the process is done with pen, paper, or mind, that maybe not. The rationale he gave is sort of like trying to set aside things that are cultural, artistic, or aesthetic in nature, and that they're
business, really business is one too.
Really business,
yeah. And so they're trying to draw this line between things that are technical and non-technological in nature without necessarily using that term non-technological, because on the basis that the patent system was historically meant to cover things that touch on technology, but there were some pretty reasonable concerns that were expressed around, potential for unintended consequences, right? The phrase keeps coming up, with process language, because things like the BCD algorithm, this was an example of something that was, highly technological in nature, but that could be thought of in the mind and done on paper, right? So just given the volume of discussion and the questions that arose from U.S. Inventor members during this particular call, I think that demonstrates that there's still some room left for, interpretation around these things. And so we know that's where the courts have gone wild in the past. So the question is a long lead up, but the question is, are these concerns sort of just, misunderstandings, or are they really just sort of the inevitable casualties of compromise and getting to a system that's infinitely better than what we have today?
Yeah, that's a really great question. And let me reframe it a little bit. Sure. By first recognizing and identifying that we have a serious problem in our patent system. The U.S. Supreme Court has turned our patent system on its head and has reversed decades, if not centuries, of a general approach within the United States of securing new innovations in the cutting edge areas of the U.S. innovation economy. Processes were part of that, and a very important part of that in the Industrial Revolution, and even in the biopharmaceutical revolution of the 20th century. And they continue to be in the biotech revolution and in the high-tech revolution of the late 20th and now 21st century. So we definitely have a problem. Also, processes as inventions have historically been kind of a nettlesome area in patent law, hard to identify, exactly with precision, the patentable process as an invention, as a process, as distinguished from the instantiation of that process and the various examples or embodiments, as we say in patent law, that you see it deployed in the world. And this Supreme Court has vacillated back and forth over the past couple centuries in various cases, and emphasizing the importance of securing and recognizing the process, but at the same time not limiting it just to its particular embodiments. And at the same time, sometimes saying, well, but you can't have a process that's distinct and separated from the particular embodiments and things of the sort, because then you can do it in your, in your mind and things of this sort, and that's not patentable. And so the concerns about how you kind of define with precision process is not new in patent law, and it won't go away. Because it is a very difficult area to identify with analytical precision and conceptual precision. Exactly, well, if you're protecting steps that do something to achieve something, which is a human innovation in itself, and that was as we've talked about in the past, was a improper innovation of the founders to recognize as something that should be a patentable invention, as distinct from and refusal to recognize that in England and in other countries. It's important nonetheless, to recognize that we should continue to try to protect these issues. And so people who are concerned about that, there might be some restriction or undue restriction on the ability for people to obtain process patents. That's a legitimate concern if they have that concern. But I don't think the concern in this context is coming from the right place, in the sense of, legislation will never be bulletproof. You can't write a piece of legislation that can never be misinterpreted by courts or misapplied by courts or even the U.S. Supreme Court at the end of the day. If that's your standard, like we can only enact a bill that will provide us with 100% certainty that a court, whether a district court, whether the Court of Appeals for the Federal Circuit, or whether the U.S. Supreme Court, will never ever be able to misinterpret this. Well, that can never happen, and we would never have legislation. Now, maybe that's a good thing. Maybe people don't want Congress to be enacting laws, and that would be. And frankly, I take that position with respect to a lot of areas. But we do need Congress to enact patent laws, so because there isn't any patent law if we don't have Congress enacting patent statutes, so that can't be our standard with respect to patents. And what you try to do is you try to address that, and you try to cabin in as much as possible, by writing, precise statutes, and setting forth now what has become a normal practice, which is findings in the statute, because that makes it very clear what Congress and enacting the statute means in the actual statutory language itself, which is really important, because you don't want courts engaging in shenanigans by picking and choosing pieces from legislative history or offhand comments by particular senators or congresspersons as to what they think the legislation meant, because Congress enacts the legislation, and if the legislation includes findings, and that is that's part and parcel of the public meaning of that statute. So I worry that there's kind of this concern about perfection in enacting legislation that is driving some of the criticisms of patent reform legislation more generally, and that kind of classic adage of letting the perfect become the enemy of the good is really undermining the ability for us to actually enact legitimate, necessary patent reform legislation, because the Patent Eligibility Restoration Act is really important. By and large, it is the best piece of proposed reform we have at the moment, and I don't see any others. And unless someone has an alternative bill to introduce that actually is better, then we need to go with the legislation that we have, and the legislation that we have is pretty good. Now, are there aspects of it I don't like? Yeah, I think it's a little too detailed. Or more precisely, I think it's too much detailed. I prefer kind of more general, broad language like you see in the 1952 Patent Act. But, notice people could have the same criticisms of that general, broad language that they have of the current Patent Eligibility Restoration Act. Oh, that allows for shenanigans by courts because it's too broad, right? And so you can kind of see how, senators feel like they're caught in a situation where it's no win for them, right? If they write legislation that's too broad, they get attacked that doesn't actually cabin in the discretion of courts. So they try to be more precise, and then they get criticism from people like me saying you're right, you're doing too detailed statutes and you're not covering it, and they still get the criticism from the people who are saying this still doesn't prevent courts from engaging in shenanigans, because at the end of the day you can never fully prevent that from happening if judges really want to do it. But I think it is significant that the Patent Eligibility Restoration Act is very clear that it is abrogating the exemptions. It is very clear that it is addressing specifically the at least the three really bad decisions, Mayo, Myriad, and Alice. Bilski isn't really bad, if only because Bilski recognized that business methods are patentable. It still reached the wrong decision in that case as a matter of patent eligibility, but nonetheless, it was still was the general holding that these types of inventions are processes and can be protected as such is important and good, and that's so that makes Bilski something of value. And by the way, notice then that Bilski really hasn't played much of a role in all of the bad decisions. It's been largely rooted in Alice, Mayo, and Myriad. And I think the legislation is very clear that those decisions are overruled. And it addresses the misrepresentations and false arguments made about the efforts at patent reform, such as you can't get a patent on a gene in a person's body and things of this sort, which have been the allegations that have been spread by academics and by the ACLU and other organizations, which are outright misrepresentations of what the legislation actually achieves in its plain language and in its intent.
It does seem like it does seem like it moves it closer to because I feel like the heyday pre-AIA was you tied up, it's in the software space, you tied it to a computer. It was clear that it was not in the mind, right? That, this was meant to be executed on a computer. It has computer specific language that disjoins it from, solely the human mind. So I feel like it does move us back closer to that part of the pendulum swing than we currently are, at least in the software space. So,
yeah. So, it's really interesting that Josh mentioned, the binary conversion algorithm that is at issue in Gottschalk v. Benson, or Benson v. Gottschalk. Because that decision has spawned so much confusion and unfortunate approaches to patent eligibility for computer inventions and in patent law more generally. First of all, it's notable that Benson v. Gottschalk is decided by Justice Douglas, who, and I'm not being bombastic here, is notoriously anti-patent or patent skeptical justice, who really, viewed these as monopolies and thought that they shouldn't be issued except in the most kind of, extreme examples of like groundbreaking, ground-shattering inventions. Also, that in his opinion, he, frankly misrepresents the patented invention, because the invention is not on the pure algorithm of simply converting binary into 10-base systems and vice versa. If you actually read the claim, it actually is tied to the operation of a logic gate in actually a chipset. So it's clear that it's made to function on a computer. And the computer program that we're talking about is the computer program that makes computers functionable as computers. So this isn't just simply an invention that we just happen to do it on a computer. This is an invention that is an invention in the computer space, and certainly should have been patentable and was patentable until Justice Douglas converts it into this alleged claim of a pure algorithm. And by the way, that's the other issue that Benson v. Gottschalk is really problematic, which is that actually it is Gottschalk v. Benson, I think, that is actually the first time that the phrase algorithm is introduced into patent law, and becomes this kind of baseline for understanding, what is patentable and what is not. Is it just an algorithm or not? For the, as I always kind of teach when my students, right, an algorithm is just a method or a process of doing something. So when you learn in school to take advantage of notational placement in 10-base systems, number systems, and you stack 14 plus 4 plus 8 on top of each other with respect to their notational placements, that's an algorithm. And you're right, that's not patentable. But that's not what was being patented in Gottschalk v. Benson. What was being patented was this computer program that makes computers function as computers. And that is a technological invention. Now, this is a great example of how you can't make statutes bulletproof, right? Justice Douglas could have done that. Justice Breyer did that, and Alice, and I'm sorry, in Mayo, and in other decisions, and Justice Douglas did as well. You can't stop judges from, if they want to impose their particular views on what they think should be patentable or unpatentable on the system. But what you can do is at the core make clear what inventions are patentable and are not patentable, and the Patent Eligibility Restoration Act, achieves that in the best way possible in our current context. And so for that reason, I think we should support it. And until or unless someone actually has introduced a piece of legislation that is better, actual legislation introduced, co-sponsors, that is better and demonstrably better, that it isn't susceptible to the exact same criticisms that are being made against the Patent Eligibility Restoration Act, then I think we need to talk about why we should be enacting the Patent Eligibility Restoration Act. It's always easy to harp on and criticize on the edges. But at the end of the day, we need to reform the patent system. We need this important reform. It's not going to come from the U.S. Supreme Court, which has now denied well over 50 cert petitions to ask it to reconsider its application of we now refer to as the Mayo-Alice or the Alice-Mayo framework. And so the only last place it can come from is Congress. And Congress is doing its job, just like it did its job in 1952 in overruling the flash of creative genius tests that was manufactured by, I believe, Justice Douglas and Kuno Engineering, that made it impossible for people to get inventions under what was then known as the invention test, and becomes known after 1952 as the non-obviousness inquiry.
Yeah, and it's not just could we have something that's demonstrably better, but it's also something that's politically viable, right? Like you have to consider the machine that has to go through as well, and that it's hugely important that Congress signal back to the courts that Congress is taking back control of patent law. And you have to get there, but you have to get there via something that can actually pass. And that was one of my big takeaways from listening to the judge talk about it. Was he said it's bipartisan, it's bicameral, and it's a version of eligibility reform that's actually politically viable, right?
Yeah.
Which that part's huge. And like you said, some of that is going to be a product of compromise, but he also, he said that this takes away every possible opportunity for the courts to mess with congressional intent on eligibility, take almost every possible, but he kind of went on to give that some extra color, and the way the judge does. He said, he says this excludes courts from mucking with 98% of eligibility concerns, but we're still left with 2% because statute requires the use of language.
Yeah.
Right?
Yeah. As always, the inimitable, Judge Michel, said it far better than I. And that, you can't escape at the end of the day, as all lawyers know, the inherent ambiguities that occur in language. And this is why lawyers exist. This is why, and it's just a fact of the world that we have to address, that there will always be, what we refer to in the law as edge cases, or cases on the margins, that raise, potential indeterminacy and potential concerns. But the question is but it's not the edge cases that should be driving you. What should be driving you is, does this address the core issue that you're concerned about? And what are we concerned about? You can't get patents in biotech right now on DNA and on diagnostic tests and on all the things that have wrought our incredible biotech revolution and have made medical treatments that were thought of as pure science fiction even just 20 years ago that are now standard today. You can't get patents on high-tech innovations, on computer software and CGI and on AI now. AI is starting to be, held to be invalid because, that's just human thought. And meanwhile, you are getting patents on these things in China and Europe. So, is the United States, where do we want to be as the United States? Do we want to be the leader in biotech and in high tech and AI and automated cars and all these things, or in 5G or 6G? Or do we want China and Europe to lead on these things by where they secure to their innovators these types of new innovations? So, I think this is a fundamental choice that we have to face and recognize. And I think the PERA Act, as it's come to be called, addresses this and addresses this quite well.
It's a great segue to another one I wanted to add. Can I ask you another one? You have time? Okay, great. Okay. And I don't know to what level of specificity this can be answered, because I think answering it with the highest level of accuracy would probably require a research project, and I don't know if that research has been conducted at this stage, but I'm going to ask the question anyway. And that's just, it's been stated that China's leading the US in 37 of 44 critical technologies. I've seen that cited a handful of places. Mm-hmm. I know that you've taken a look at this in the past on real innovations that were eligible in China and elsewhere, but weren't in the US, and the numbers were pretty staggering. If we compared this bill to current Chinese law, assuming PERA is passed, would China still be more flexible, or how many of those 37 technologies can we become more competitive in from a patenting perspective? What does, practically speaking, and those metrics that we can look at across innovation right now, how does this bill change the landscape?
It's a great question, and it's not a question you can answer empirically in the sense of providing exact 102 patent applications sure. would have been denied. 101 of them will now be approved in the United States. It's a question that you can only answer in kind of in a general framework and institutionally. That what PERA signals to innovators in the space of AI, Internet of Things, autonomous vehicles, 6G, and so on, is that these are patentable inventions, and that if they're going to be excluded, they're going to be excluded from the patent system on classic grounds of novelty, non-obviousness, full disclosure, and utility. And we are no longer going to be susceptible to this kind of willy-nilly decision making by judges, where they disintegrate your claims down into particular elements and then say, well, this element is obvious, and the guy can, who's known in the art and think of this, and this element is obvious and known in the art, and I can think of this, and so on, which is what they've been doing. And so that is the significant, that is at core, in its essence, the significance of the PERA Act, or PERA, the Patent Eligibility Restoration Act, is that it reestablishes the grounding of the general promise of reliable and effective patent protection for innovators at the cutting edge of high tech and biotech in the United States. And now, if China continues to provide the same levels of protection, so what then is still the competitive advantage of the United States? Well, at that point, then the competitive advantage becomes our classic competitive advantage over China, which is rule of law, stable political institutions, and when you combine that with our patent system, that's what gives us then the competitive edge globally that has been the basis for why we have been a technological leader for the past 2+ centuries, and that's what we need to reestablish.
Absolutely. Earlier, you mentioned the abrogation of 3 of the 4 dreaded horsemen of the innovation apocalypse in PERA. One comment I saw on this I thought was particularly caught my eye anyway, and it was just that there have been Supreme Court and Federal Circuit rulings that have required a clear and certain signal from Congress on new legislation. And it's my understanding that the abrogation appears in the findings section of the bill and not in the statutory language. Is that any cause for concern in terms of that clear and certain signal from Congress to the courts?
So does PERA provide a clear indication of the abrogation of at least three of the four horsemen of the innovation apocalypse that have been produced by the U.S. Supreme Court? So the question focuses on what is referred to often as the clear statement rule, which is a general rule of statutory interpretation, which states that when in construing statutes, particularly in the context of whether a statute abrogates or overrules common law doctrine or prior court decisions, what the Supreme Court has historically required, and all courts actually historically require, not just Supreme Court, is that the legislature explicitly state in some way, shape, or form that it is doing so. So they will not read abrogations of prior law as having been achieved impliedly or lightly. And it's understandable why this very kind of core rule or canon, as we call it, of statutory interpretation has evolved over the centuries, is because given a system of both common law as well as even with statutes, people need to have settled expectations. You need to have a sense of the rule. If people could make arguments, given inherent ambiguities in language, that, oh, well, Congress was, or any state legislature was impliedly overruling either a common law doctrine or a prior statute, these arguments would be made all the time, and you would never have any settled law. Now, the clear statement rule does not actually require Congress to explicitly say this specific doctrine is overruled, or this specific rule from the common law rule is overruled, or this particular statute is overruled. Sometimes Congress says that, but it doesn't need to do so. And in fact, a classic example of this is the explicit abrogation of the flash of creative genius test in 1952 Patent Act Section 103, which contains two sentences. The first sentence is the positive sentence, which says, you shall look at the claimed invention as a whole. And, it's assessed according to the standard of a person having ordinary skill in the art. The second sentence simply says, nor shall an invention be negatived by the manner by which it was created or invented. That's kind of, I'm recalling it off the top of my head. Notice it doesn't specifically identify Kuno engineering. It doesn't specifically say we are abrogating the flash of creative genius test, or the creative flash of genius test that was crafted by the Supreme Court in Kuno engineering. But it was very clear that that's explicitly what that sentence was doing. And in fact, that's exactly what the Supreme Court recognizes in Graham v. John Deere in 1966, that was the function of that sentence. So it just has to be that the nature of the statutory language that Congress has adopted has to be clear as to what it is achieving. And that is what PERA does. In its listing out of what are excluded from patent eligibility, and in its clear setting forth how courts shall determine patent eligibility, it is very clear that this conflicts with and thereby overrules or abrogates, the holdings in Alice, Mayo, and Myriad decisions.
Is there a good reason to not put it in the statute directly?
Yes, there can be some good reasons for that. So, as I mentioned, for instance, in Bilski is actually stands for two different propositions. One is business methods are patentable inventions. The other proposition is this particular business method is not a patentable invention, right? In Myriad, it says this particular or isolated genes are not patentable. But it actually also says, by the way, cDNA, the complementary DNA, the copies of the DNA that are made in the lab, that's patentable, right? So if you say myriad is overruled, then you raise additional questions of like, well, are you then overruling the complementary DNA part? That's really good,
Yeah,
or
okay.
are you overruling just the bad part, which says isolation in the lab is not patentable, which is bad. So it helps to be kind of clear as to what you are directing yourself to. And for instance, the statement that genes in the body are not patentable, but isolation, purification, or the use of any gene is a patentable invention is really clear. That is overruling myriad, the bad part of myriad, in the same way that Congress overruled the Kuhn engineering test of a flash of creative genius for obtaining a patent on an invention, in the statement that nor shall an invention be negative given the manner by which it was invented.
Yeah. Okay. Cool. That makes a lot of sense.
Yeah.
My last question is, do you think that Iger pulling up on Marvel and Star Wars is going to be good for quality of Star Wars productions or bad?
Good question. Because like not all Star Wars is good, but
Right. Yeah.
that was true even back then. Like the original trilogy, right? The Return of the Jedi. It's had some good elements to it, but compared to Empire and compared to the original Star Wars, it's like there was it was like not it wasn't up to the same level. Yeah, it's a good question because if you have a lot of Star Wars, right? Then more chances that there's something that's good, but also more bad. But then you have when stuff's bad, you're like, okay, well, but I got six other new Star Wars things that are coming, right? I mean, this was the problem with since this is the problem with the prequels, right? They were all bad, and they were the only ones, right, at the time. So we were stuck. But if you got like six shows running and two movies going and all sorts of stuff, if something's bad, like you're like, okay, that's bad, but the next one was good, and then the next one was so, and the next one's really good, and so it's always a question, like, do you want quantity or quality? And very oftentimes quality comes with quantity, because that gives you the ability to take chances and be bad, without because you make up for it with other stuff that's good.
Yeah, I don't think we ever would have gotten Andor in the box office gate kept Disney world, right?
Never. In fact, that was, in a certain sense, one of the silver linings in the in the negative fan backlash against the the sequels. Star Wars 7, 8, 9 was that Disney shifted from movies to streaming content, because in a certain sense Disney made that decision largely financially, right? It's like, well, we can blow $150 million and come up with a movie that the fans hate, or we can spend $20 million on a show, and if it bombs, well, we'll have another show lined up, and and that one will be potentially really good and we'll do okay, right? So but by shifting to this kind of shorter form streaming content, as opposed to blockbuster movie format, right? We've had some really great stuff like Obi-Wan, and Andor, and even Ahsoka potentially. We got the final season of Clone Wars. So I think it's been a pretty successful run. I mean, there's been some stuff that's been so, like Book of Boba Fett, but all in all, I've been happy with it. So I guess this is all a long-winded way of me saying I'm a little concerned that they're cutting back on the content or the quantity, because that's what's made possible them to do like lots of really good stuff, and different stuff, and appeal to different audiences. Like one of the reasons why I think Book of Boba Fett, people like you and me disliked it, was because it clearly is pitched to like the 5-year-old. Yeah. The kids love it because it's silly and it's over the top and it's absurd in a lot of ways. but the kids love it, right? And in a certain sense, that's what the prequels were all about, right? The prequels were really pitched to the 6 and 7 year olds, and that's why those of us who were older, who lived through the original Star Wars trilogy, hated it. We were like, this doesn't appeal to
Calling you
us.
out, Jar Jar.
Yeah, exactly. So I don't know. So I mean, right, to be frank, I think they're just making this decision right now because they're making a lot of really bad decisions right now financially. A lot of their movies have bombed, relatively speaking. And they're just cutting costs. So, they can use cover, like, oh, the fans are always unhappy, so we're going to cut back on content. It's like, well, okay, that's your excuse, but the reality is that you guys have just been producing a lot of flops and spending a lot of money on movies that haven't been making back, even the cost of the making the movie. And I mean, like they're like all the recycling of old, like we're gonna make live actions now, all these animated movies, and we're gonna change the live action movies to accommodate modern sensibilities, which upsets all the people who love the original the original animated movies and of the sort. So yeah, it's unfortunate, but it, at the end of the day, I think we're going to get a really great Ahsoka series, though. I'm optimistic given the quality of the source material. Yeah, Clone Wars and Rebels was incredible. Great Star Wars storytelling, and they're just kind of so they've got great characters already. So there's no propensity there to create another Jar Jar Binks, right? There's no propensity to go like silly and absurd because that's not what Clone Wars and Rebels was. And so I think that they're really going to do something great here. Whereas like Book of Boba Fett, right? They had a character that everyone loved who had a total of 8 lines in the original movies. So like they weren't as constrained by the source material in a certain sense as they are now. And in this context, constrained by the source material is a good thing because it's really good source material.
The Mando mini season was the only thing redeemable about.
Yes, exactly. Yeah, 100% agree. Yes, those like for 3 or 4 episodes in the middle of Book of Boba Fett are really fantastic because they stopped following Boba and
it became a different show.
Mando. Yeah, exactly. Yeah, Mando. We refer to it Mandalorian season 2.5. I think it's called. Yeah. So yeah, and I can't tell you how stoked I am that they got the original voice actor. I'm blanking on his name for Thrawn. I mean, because I mean, just like he's just like if anyone who's a Star Wars fan and knows Clone Wars and well, not Clone Wars but Rebels. If you say Thrawn, you can't help but hear that voice in your head.
Yeah.
I mean, which is so perfect. It's so indelibly Thrawn, and he just captured it so perfectly. And so, I just we would have all of us, I think, have had trouble if they hadn't gotten him. Imagine them having someone other than James Earl Jones as
for sure. Yeah.
I mean, just like all of us would have been like, that's not him, right? And I think that's the same now with Thrawn. I mean, just that even keel kind of voice. It's so perfect, right? I mean, it's just like, yeah.
Yep. It's like whole separate episode though, but I think it's gonna be really interesting to see where things go with the digital human stuff though, from like an intellectual property rights perspective. Because I mean they did it with Leia, and that was sort of like an understandable thing, and
I think they got approval though.
Did they get a state permission on that? Yeah. And then they didn't Rogue One. I'm not sure what the permission granting was on that, but some of this new, I've seen stuff leaking that some of the things that they're trying to get in the new contracts with the actors is the ability to basically like digitally scan and then reuse forever. And it's like you can sort of see this temptation of, like, you mean we can make movies without actor strikes or dealing with prima donnas, and we can make Mission Impossible movies like 50 more of them, because eventually Tom Cruise is going to be able to have to stop hurtling himself off from cliffs and stuff.
Yeah.
It's going to be really interesting to see where that all shakes out, because maybe legal arguments have already been made around this, but there's this weird sort of shared ownership of some of this stuff, right? Where, you've got the writer who creates a script and the director who provides the direction on how to move around, and somebody's creating costumes, and somebody wrote a book about this thing, but then you have the actor who like breathes like soul and life into the thing. And
Right.
there's some very famous instances of Harrison Ford, Tom Hanks, those kind of guys, like really creating a lot of the character, sort of on the fly. But then like who owns the future manifestation of that? And so anyway, that's gonna
I mean, it's outside of patent law, right? So now we're into copyright and right of publicity. I mean, from what I understand though, currently like copyright, like, they own the studios do own it. Like they want to now put it in the contracts, but the studios have always owned it, like given the nature of the contracts and the nature of copyright. This is all work made for hire, you're paid for it. Right. So like they can do whatever they want with it, including making derivative works. And derivative works would be, the definition of a derivative work in copyright is derivative. So AI is derivative if making continued versions of it. So I know some copyright scholars who are like, well, I get why they're all angry about it, but like now, like, but that is the law right now. Like, it's not like, they're just making it more explicit given the rise of AI, but that's always been the law. And the case with it. And, and from what I understand, more broadly, right, the disputes here isn't just AI, it's the way they record finances and in Hollywood, so that movies like are deemed to be utter failures and have never made a dime when they've been blockbusters and stuff. So I mean, these are interesting, but they definitely raise interesting issues. I believe, and even in Rogue One with Peter Cushing, that they got permission as well from his estate to do him again. And that's kind of what that's been the practice, and it shows you like they're trying to file good norms. I don't think to be frank, I don't think Hollywood has been necessarily bad in these things. That they have been trying to follow some good norms, and a lot of actors are allowing it, right? So Harrison Ford allowed himself to be made younger in the most recent Indiana Jones movie and things like that. So
have you seen that?
No, I'm gonna wait for streaming.
They did a really good job. They did a really good job with the de-aging. Like I turned my brother and I went and watched it, and I turned to him because the first part of the movie was the best part of the movie, because I mean it really took you back. The only thing that was a little bit of a leap was it was like his older gravelly voice with his younger person, and so there was like a little bit of a cognitive disconnect on that for me on that. But I turned to my brother and I was like, I would watch a whole movie like this. So I thought it was good.
That's cool. I'm just too busy right now, and that's why I'm not opposed to seeing it. Like I said, I'm just gonna watch when it comes out on whatever streaming platform. But I mean, like I definitely want to see Oppenheimer in the theater. And maybe even the Barbie movie. That's like I found the CGI stuff to be fine. Like I know a lot of people are like, oh, the Grand Moff, Tarkin and Rogue One wasn't good. I was like, I liked it. Leia and Rogue One wasn't good. I liked it. I thought they did a fine job. I mean, if you stare at the screen really hard, like it looks
pause every frame, and
exactly. But like, who's doing that? You just experience it, right? You just enjoy the moment, and frankly, that was such a it was they did such a good job at keeping it secret. Fans kept it secret, that was at the end of the movie. And given that she died 4 days before the movie was released, all of it just adds up to just really being an incredible moving and scene and moment in the movie that just takes your heart away. So breath away, for sure. Did for me, and and so I like it. Yeah, but you're right. These are interesting issues, and there's going to be litigation, and that's what we would expect. And there's going to be some interesting litigation over AI eventually too, on patentability issues and stuff. Eventually, when it reaches the point, well, the litigation won't be actually, and the issues won't be inventorship. That's just silliness. The invention, where I think the litigation will be interesting and will raise actual legitimate questions at this stage of our technological evolution is non-obviousness, disclosure, and enablement.
Yeah.
These will be well, is this fully enabling just because you used one AI platform to create this invention where I might get an entirely different result if I use another one? And is this obvious if an AI, if a faceta is, knows everything and the AI system knows everything, came up with it, is it obvious? I mean, these are interesting questions. I think those are actual interesting questions as opposed to whether we want to make robots inventors or not, which is, to me, that's just science fiction at this point.
Yeah. Tools in the process. Yeah,
exactly.
Yeah. We just did an episode. It'll be releasing later this month, and actually this Mossoff Minute stuff will go out with that, and it's on all the kind of like the pop culture stuff that's going on in copyright and trademark. So that's why some of that stuff was a little bit more.
Oh yeah, cool.
Top of mind. We do patents, but we get questions all the time about copyrights and trademarks. We're good friends with a brand protection attorney, so we figured, well, what the heck, we'll put something out there, and it'll be a fun one to do because there's the Jack Daniels stuff and the Andy Warhol stuff and the 100% That Bitch and the Wall Street Bets stuff that's going. I mean, there's just like a lot of really kind of like fun poppy things to talk about that you don't always get to do in this space. So
yeah, that's really cool. Yeah. Well, I mean, I get those questions too. And I always get to delightfully say, "Well, I'm not a copyright person, so I don't." But here's my somewhat uninformed opinion.
Yeah.
All right. Well,
I'll let you go. Thanks for all the time.
Back for both of us, but it was good seeing you. Enjoyed the chat, and please tell Ashley it was good seeing her, and looking forward to seeing the new content come out. You guys are awesome.
Sounds good. I'm making the pilgrimage to see Oppenheimer at one of the 30-70 millimeter IMAX theaters this weekend. So I will let you know how it is.
Cool. Yeah, definitely text me and tell me what you think. I mean, okay. I'm certain it's awesome because
oh, confident.
Yes. It's Christopher Nolan.
Exactly.
Yeah. All right. Cheers, my friend. Have a good one.
You too. Bye.